Good afternoon, everyone. My name is David Friedman. I'm a lawyer at Wagner Sidlowski and the co-chair together with my colleague Peter Neufeld of this Lunch and Learn series on family and estate law. The topic that is being considered today is an overview of the equalization election. A paper was prepared by Bradley Phillips in advance of today's seminar on this topic, and a link will be found in the chat bar. There'll also be a certificate of attendance for you that will be in the chat bar as well. If it's not there now, it'll be there. Just a couple of things to note. First of all, this is being recorded. Second, I'd be grateful if you could please keep your microphones muted unless you're asking questions at the end of the presentations. And after you ask your question, I'd be grateful if you could please mute your microphone again. There are three people that are presenting today. First is Brad Phillips. Brad practices in the areas of estate litigation and commercial litigation. And he's also certified as a trust and estate practitioner by STEP. Aaron Betts and Alyssa Weinerman are both partners at Epstein Cole. Both are widely experienced across the full range of family law, whether in court or in arbitration or in mediation. And if you go to their firm's website, you can find their bios online, and both of them are far too accomplished for anyone's comfort. Let me now move on to thank our sponsors. Scotia Wealth Management, B'nai B'rith, Epstein Cole, Concentra Trust, BMO Private Wealth, PD, Torkin Mains, Solus Trust, and Weir Folds. This event is complimentary due to their generosity. If you enjoyed our seminar, we would ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't done so already. And there should be a link in the chat bar for that purpose. Elite Mannheim is the manager of legal affairs at B'nai B'rith Canada, and she is here with us today, and she can tell us a little bit about the organization and its charitable work. So over to you, Elite.
Thank you very much, and good morning, everybody. I'd like we've been asked to speak a few times, so I hope and know that most of you know who we are, what we do. But I would like to touch based on one little topic that has recently been introduced by B'nai B'rith Canada as part of our efforts to combat anti-Semitism. So due to the rise and escalation of anti-Semitic incidents B'nai B'rith Canada has encountered in the past year, I would like to introduce to you B'nai B'rith's newest initiative to combat anti-Semitism on campuses across Canada. In a news conference Friday morning, September 13th, B'nai B'rith Canada announced that it has developed a comprehensive policy for universities to use as a go-to resource for addressing unprecedented levels of anti-Semitism, which have spiked since Hamas's terrorist attack against Israel on October 7, 2023. The policy not only proposes measures to protect against anti-Semitism, but enables post-secondary institutions to take proactive stance against disinformation and the rewriting of historical events. It's called B'nai B'rith Policy for Combating Anti-Semitism on Campus, or in short, PCAC. I will shortly add a link to this policy in the chat for everybody's knowledge. The adoption of a PCAC would represent a commitment to upholding the values of truth, justice, and equity for all members of our campus communities. The framework, shared with all universities across Canada, was developed after NABRIF asked institutions in the lead up to the 2024-2025 academic year how they plan to protect Jewish institutions this year. In response, most schools said through existing policies and frameworks already containing safeguards intended to combat and protect students from racism and hatred. The issue is that there is a lack of understanding of what is anti-Semitism, what anti-Semitism actually means. University needs a better definition of anti-Semitism to improve their existing anti-hate policies and ensure that Jewish persons, and I'm referring to students, staff members, professors, and so forth, are included within existing framework. PCAC is meant to fill this role by enhancing existing policies. PCAC has already received the endorsement of the Canadian Union of Jewish Students, CUJS, which was reestablished in late 2023 to serve as the voice of the Jewish university students amid rising levels of anti-Semitism on campuses across the country. NABRIF Canada looks forward to the universal adoption of PCAC and its acceptance as a common phrase in Canada. Thank you for taking the time to listen to me.
Thank you very much, Elite. I'd like to now invite our presenters to make their presentations. Brad is going to speak first, and then hand it over to Aaron and Alyssa, and then I believe that Brad will be speaking again. We'd be happy to take, or our presenters would be happy to take your questions at the end of their presentations. You can post your questions if you'd like in the chat bar, or you can ask your questions directly on screen as you wish. So over to you, Brad.
Thanks, David, and good afternoon, everyone, and welcome. Today's topic, as you are aware, is the family law election. When a spouse dies, in most cases, the scenario is pretty straightforward. The deceased spouse leaves his or her estate to the surviving spouse in a will, or they may hold most of their assets jointly, so the surviving spouse receives the assets by right of survivorship. But of course, estate litigators really wouldn't have much to do if there weren't some exceptions to the norm. Some of these exceptions arise where, for example, the spouse was wholly disinherited in a will because they were separated but still legally married at the time of death, or it's a second marriage and the spouse decided to leave everything in his will to the children of his first marriage. So there are many permutations and combinations where a surviving spouse may believe that they've not been adequately compensated by their late spouse's estate. And when these types of scenarios arise, the very nature of a spousal relationship will impact upon considerations that a surviving spouse may have to weigh if they've not been adequately provided for. So, for example, a common law spouse has fairly limited options. If their spouse dies without a will, as a common law spouse, they do not have any right of inheritance on an intestacy under the current provisions of the Succession Law Reform Act, or the SLRA, which I'll refer to it as going forward. Only a married spouse has that right. And similarly, only a married spouse a married surviving spouse has the right to elect to receive an equalization of net family property under the FLA, or the Family Law Act, upon their spouse's passing, which is obviously the topic that we're going to focus on today. And I appreciate that some of you are very familiar with the family law election and its purpose and procedures, but for those less familiar, under Section 5 sub 2 of the FLA, when a married spouse dies, if the net family property of the deceased spouse exceeds the net family property of the surviving spouse is entitled to 1/2 of the difference between them. And this payment is known as an equalization payment. To receive the benefit, the surviving spouse must elect to either receive this equalization payment or receive their entitlements under a will, or an intestacy or partial intestacy, as the case may be. Like all good rules, there are exceptions to them. For example, when the will expressly states so, a spouse can receive both under the will and pursue a family law election, but that is not the norm. Significantly, however, making an election to receive an equalization payment does not necessarily bar a surviving spouse from also bringing an application to seek dependent support under Part 5 of the SLRA. And this fact gives rise to some interesting procedural questions or challenges that we'll discuss later. So the ability of a surviving married spouse to pursue a family law election and or a dependent support application gives rise to a number of scenarios that a surviving spouse has to consider. The married spouse could choose to receive the bequests under the deceased spouse, under this deceased will, or if applicable, their entitlement on an intestacy or partial intestacy. They could receive the bequests under a deceased spouse will, but or under an intestacy, but also seek dependent support on top of that. They could pursue a dependent support application if he or she was entirely excluded from the spouse's will. Or they could choose to make a family law election and receive the equalization of net family property under Section 6 of the FLA, which has the effect of disclaiming any gifts under the will or on an intestacy. Or they could receive an equalization of net family property and receive the bequest under the will if this is expressly permitted. Or they could pursue both a dependent support application and an equalization of net family property. The bottom line is that, bluntly, in order for the married spouse to determine what is in their best interest, is you have to look at what is ultimately going to be most financially advantageous to them, which leads to the next logical question, which is, how is the value of an equalization payment determined? And for that, I'm going to pass the mic to Alyssa and Aaron to provide their family law expertise about this.
Thank you, Brad. So there's often a misconception that when married spouses separate, they divide all their property owned by them in half. That is not how it works. In Ontario, on a breakdown of a marriage, everyone keeps the property that is in their name. And what is shared is the growth in the value of the property accumulated by the spouses collectively during the marriage. So on a breakdown of a relationship, which includes, a married relationship, which includes a separation or the death of a spouse, each party is entitled to retain what they own, subject to the requirement that one married spouse or his or her estate may have to make a cash payment called an equalization payment to the other spouse. In order to calculate the amount of the equalization payment, to affect the sharing of the growth in the wealth accumulated by the married spouses during the marriage, each spouse's respective net family property, or NFP, must first be calculated. Calculating NFP can have quite a few complications, but I'm going to try to explain as simply as possible the steps involved in calculating NFP. Once I'm done that, Erin will explain how to calculate EP, or equalization payment, and she'll get into a few other issues specific to the equalization election. So in summary, a spouse's net family property is the net growth in that spouse's wealth over the course of the marriage from the date of marriage. And it's important to note that it's the date they actually legally got married, not any other day, not the day they started living together, if that was before then, to the valuation date. The valuation date is the earliest of A, the date the spouses separated, which is usually what we are dealing with in our family law practice. B, the date the spouses divorced or the marriage was declared a nullity. So that is sometimes what we deal with, but not as often. Or C, which is most relevant to the seminar today, the day before the death of the first spouse. And the reason it's the day before is quite important, and I think Erin will touch on that a little bit later, and not the date of the death. The first important part about calculating NFP is knowing both dates, the date of marriage and the valuation date, so that you can calculate the growth between those two dates. It's also important to understand at this point, when we're calculating NFP, that we're looking at each spouse separately. We later, after we've calculated each spouse's NFP, compare the two, and that's how we determine the equalization payment. With that in mind, the first step is to look at the value of whichever spouse's property we're calculating on the valuation date. The definition of property under the Family Law Act is very broad. So when we're looking at this and calculating for the valuation date, all property owned by that party, it's very broad. It includes all assets. So things like real estate, vehicles, bank accounts, RSPs, investments, pensions, businesses, and all debts or liabilities such as mortgages, credit cards, loans, contingent disposition costs, and more. It's also important to note that if a spouse has a joint interest in any asset or debt, we only consider for the purposes of that spouse's net family property the actual interest they own. So if the spouses own something jointly where they each own 50%, 50% of that asset would go on each spouse's side. Or if they own something jointly with someone else, again, just their interest, whether it's 50% or otherwise, would be part of the calculation of their valuation date property. So once you've calculated the valuation date property, then the second step is to determine and subtract from that number what they owned net of liabilities on the date of marriage. This is called date of marriage deductions. It is often difficult to determine or prove date of marriage deductions, especially if there's no records and especially if the marriage was long. Leaving that aside, if or once a number can be determined and ideally proven, that number is, as I said, subtracted from the amount we previously calculated about the spouse's net worth on the valuation date. If a spouse entered the marriage with a negative net worth, the date of marriage deductions actually seek to increase their net family property because you're subtracting a negative number from the valuation date net worth. So in those cases, it's actually not in a spouse's benefit to be able to prove the date of marriage assets or date of marriage deductions. But those are also usually the cases where the other spouse knows about them and is happy to offer up that information even without proof. I'm going to give you an easy example just to sort of go through the calculation so far, and we aren't quite done. But if a spouse came into a marriage worth nothing and they left the marriage worth $100, then at this point of this calculation, their NFP is 100. They've grown from 0 to 100. But you can also have an NFP of 100 in a couple other scenarios. So if you came into the marriage worth $100, for example, and you left the marriage on the valuation date worth 200, your growth is still 100. So what you're sharing in that case is still your net family property of 100, even though you are leaving the marriage worth 200. And going back to just the last thing I talked about before my example, if you came in worth negative 100 and you left the marriage worth 0, you also have a net family property of 100 because you've grown from negative 100 to 0. So I give these simple examples to illustrate what I said at the beginning about how we are sharing the growth in wealth and not actually splitting or sharing the property owned at the valuation date. But we're not quite done. There's one further aspect to calculating NFP before we get to calculating the equalization payment. After you determine the growth in each party's wealth over the net wealth over the course of the marriage, we subtract from that number property that exists on the valuation date and that has already been included in the calculation of the valuation date property if it's within the category of assets that are considered excluded property. Section 4 sub 2 of the Family Law Act defines excluded property and that a spouse can take out or exclude from the calculation of their net family property. And it includes the following: property other than a matrimonial home that was acquired by gift or inheritance from a third party after the date of marriage, income generated from that gifted or inherited property if the person who gifted or the testator has expressly stated that it is to be excluded. Certain types of damages or insurance proceeds, and also property, again, other than the matrimonial home, into which property in these other categories can be traced. The most common category or categories of excluded property that we definitely deal with in the family law context are all types of gifts and inheritances, and then property traceable to those gifts and inheritances. When preparing a calculation of NFP, it's important that all property, including this excluded category, is included at first instance, as I explained before. And then it's taken out of the calculation at this later step of the calculation, assuming it qualifies as excluded property, can be proven, and most importantly, that it still exists. And what I mean by this is that you can't exclude something that's not already in the calculation. So for example, if someone was gifted $100,000 during the marriage, but all the money was spent and it no longer exists at the date of separation, there's no exclusion for the $100,000, even if it is very clear it was gifted after the date of marriage. It just can't be excluded if it's not in the calculation in the first place. Some other important aspects regarding excluded property, and specifically excluded property related to gifts and inheritances, is that the gift must have been received after the date of marriage. If it wasn't, just as a side note, it's part of their date of marriage deduction, so it wouldn't matter if it's a gift or inheritance because they had it at the date of marriage. And the other important aspect is that it loses its designation as excluded property if the funds are traceable into the matrimonial home. And we could have a whole other seminar on that, so I won't get into that. I think the final point I'll leave you with about this calculation before I turn it over to Erin is that a spouse cannot have a negative NFP. So if the mathematical calculation I just described would result in a negative NFP, because a spouse's net worth decreased over the course of the marriage, the spouse's NFP is deemed to be zero. Over to Erin.
Okay, thanks, Alyssa. So yes, so calculating the NFP, as Alyssa has just explained, can be tricky depending on the case. So calculating the NFP can be challenging, and more importantly, actually proving it, as she said, as well. And once you've actually determined and finalized what the NFP of each party is, calculating the equalization payment is actually very easy. So each party has presumably sworn a financial statement that calculates what their net family property is. And then we have, there's a specific form called an NFP statement, net family property statement, where you just basically plug that information into the software or into the form, and it will generate what the equalization payment is for you, which is quite helpful. So you don't need to really get out the calculator and that kind of thing necessarily. So essentially what it is if someone, sort of jumping off of Alyssa's example, if someone came into the marriage with, let's say $500,000, okay, this was a second marriage, for example, they came in with 500,000. And then they went up to $1 million on the valuation date, the growth would be 500,000. If somebody else came into the marriage with zero and the value of their net worth increased by 500,000, well, actually, there wouldn't be an equalization payment in that case because they both had growth of 500,000, right? Someone went from 500,000 to $1 million. Somebody else went from 0 to 500,000. The NFPs are both 500,000. So there is no equalization payment owed. If, however, somebody came into the marriage with nothing, their date of marriage net worth was 0, and they went up to $1 million as of the valuation date, and someone came into the marriage with 0 and they only grew to, let's say, 500,000, then there would be an equalization payment equal to 1/2 of the difference of their net family properties, okay? So if somebody's at $1 million, someone else has grown to 500,000, in order to equalize their net family properties, the person with the higher net family property would be, let's say, $1 million, all right? So in order to equalize, they would owe 1/2 of the difference. The difference is between $1 million and 500,000 is 500,000. Half of that is 250. So they would make an equalization payment to the lower net worth spouse of $250,000 to bring that person from 5 to 750, and that person goes from $1 million down to 750, and that's why it's called an equalization payment. Okay, and again, there's software that will actually calculate it for you, but that is essentially what it is at its simplest form. So as Alyssa had mentioned, there are other complexities posed by calculating somebody's NFP. You can have disputes about valuations, exclusions, depletion of assets, etc., which is not covered necessarily in our paper. But there are complexities as well that are unique to the election process, because there are certain assets that may arise upon death, such as life insurance proceeds, for example, which did not exist on the date before death, right? And so again, the valuation date is the day before the spouse's death, right? And so if they didn't exist on the valuation date being the day before death, such as life insurance proceeds, that doesn't form part of that individual's net family property. Same thing with liabilities, funeral expenses, estate administration expenses. Those do not form part of the deceased spouse's NFP, because the valuation date, again, is the day before death. However, there are certain liabilities that do crystallize on death that can be taken into account if the liability existed on the valuation date, and there was a likelihood that the liability would be payable in the foreseeable future. So Alyssa had referred to in her talk about certain notional disposition costs. So in the context of separating spouses, an asset, for example, like an RRSP, there's an inherent tax liability, all right, associated with that we then take into consideration. Depending on the complexity of a case, we might even engage an actuary to calculate what the appropriate contingent tax cost or notional tax liability would be, taking into considerations of net present value and present valuing the notional disposition costs. So that's just some examples of some of the unique and sort of special considerations that arise in the context of calculating someone's NFP and equalization payment in the context of an election or death of a spouse. And I'll turn it over to Brad, and happy to take questions at the end.
Thanks, Erin. So, as Erin just alluded to, first and foremost, given the need to make a calculation of NFP, you obviously need financial disclosure. And this is information that may not be quickly available to either the surviving spouse or the estate trustee for the deceased spouse. But under the FLA, a surviving spouse must make his or her election for an equalization of net family property no later than 6 months from the date of death of the first spouse, unless the court grants an extension of that time. Otherwise, they'll have been deemed to have elected to take under the will or under an intestacy. So practically speaking, whenever a surviving married spouse initiates litigation against their deceased spouse's estate, one of the grounds for relief we typically seek is for an extension of time to make an FLA election, which is permitted under Section 2 sub 8 of the FLA. And obviously that's a necessity, given that you may just not have the ability, the documentation, the disclosure, able to even make a calculation of NFP to determine whether or not an election is advantageous. So pursuant to Section 2 sub 8 of the FLA on a motion, the court may extend the time for the election if the applicant satisfies the following three-pronged test for the court to grant an extension. One, there are apparent grounds for relief, and apparent grounds for relief has been interpreted by the court to mean, but for the limitation that acts as a bar, i.e. the 6-month time period, are there apparent grounds to support the claim? Two is the relief is unavailable because of delay that has been incurred in good faith, such as the need to get disclosure information. And three, no person will suffer substantial prejudice by reason of the delay. And the applicant has the burden of proving that they satisfy these factors. And as well, ultimately, an extension is discretionary, and the court may deny the application for extension, even if the criteria are met, depending on the specific facts of the case. Another practical reality that I alluded to earlier was that if the surviving spouse has a potential family law election option, they will also likely similarly have a potential dependent support application that they could pursue. So again, just as I mentioned a moment ago, it's very common that litigation commenced by the spouse against the deceased estate will include both an extension of time, or will include seeking both an extension of time to make a family law election, and in addition, or in the alternative, to seek dependent support. And that leads to an interesting question about how the family law election process and the dependent support application procedurally interplay. Some authors suggest that the court must first adjudicate the equalization claim prior to the adult dependent support claims. And this opinion presumably flows from the fact that the FLA expressly provides that a spouse's entitlement to an equalization payment has priority over an order made against the estate under Part 5 of the SLRA, which is the dependent support application, except for a child of the deceased spouse. So practically then, the determination of the FLA election has to proceed first, because depending upon the quantum of the equalization payment, the dependent support claims would be subject to this priority that I just mentioned is under the FLA, and the dependents would need to understand what remaining assets are available from the estate. And further, in respect of a spouse's dependent support claim specifically, under the SLRA, one of the factors the court takes into account is whether adequate support has been provided to the dependent. And certainly the quantum of the equalization payment received by the surviving spouse would be a factor in that determination, which all suggests that that's the manner in which an equalization claim versus dependent support claim would be dealt with procedurally. That being said, nothing's ever that straightforward, because there's also a court, the Ontario Court of Appeal has previously noted the necessity of the court to deal with the claims of all dependents, factoring in the interests of spouses and adult children, where there isn't even a current claim being sought. So that would suggest that perhaps the Part 5 dependent support claims may need to be dealt with first. Given these sort of inconsistencies, our suggestion as a best practice on behalf of a surviving spouse would be to commence an application dealing with both the Family Law Act election extension and the dependent's support claim within 6 months of the deceased passing, and to look to the court for guidance on how to deal with the order of adjudication given the competing statutory priorities. The other issue that can arise is in terms of how the FLA election may impact upon the administration of the estate. And so, for example, first, if the spouse is in fact named as the estate trustee, and then they now want to pursue a family law election, it would place the surviving spouse in a conflict of interest because they are effectively seeking a distribution that is different from the wishes of the testator and potentially prejudicial to other beneficiaries under the will or on intestacy. So accordingly, it may be necessary for the surviving spouse to then renounce their position or even obtain an order resigning their position if they'd already taken some steps to administer the estate before they decided to pursue this family law election option. And second, even if the estate trustee is not a spouse, they need to be cognizant of the family law election, because an estate trustee is precluded from making any distribution of the estate within 6 months of the deceased spouse's death without the written consent of the surviving spouse or a court authorization. And that obviously ties in directly to the fact that the surviving spouse has a 6-month time period post-death to decide whether they want to make that election. So if the estate trustee does in fact make an interim distribution within 6 months of the deceased spouse's death without obtaining consent or a court order, the estate trustee can be found personally liable to the surviving spouse for the diminution in value of the net family property to which the spouse would otherwise have been entitled. So if you're acting on behalf of an estate trustee, you as a lawyer may have an obligation to make them aware of these issues to prevent them from potentially having personal exposure from that. So now I'm going to shift the scenario a little bit. What happens when the 6 months passed post-death, no election has been made, nor has an application been sought, and the estate trustee proceeds with an interim distribution, and only then the surviving spouse seeks an extension of time to make the FLA election, which is then granted by the court. So first, in this scenario, under the FLA, any property of the deceased spouse that is distributed before the date of the order and without the estate trustee having notice of this application will not be included within the calculation of net family property. But as soon as the estate trustee is subsequently given notice of an application by the surviving spouse for an extension of time to seek equalization, the estate trustee must then not take any further make any further distributions out of the estate without the written consent of the applicant to the distribution or a court order. There is a notable exception to all of this, which is an estate trustee may make reasonable advances for the support of the deceased dependents under Part 5 of the SLRA without needing to seek consent or a court order. And because a dependent can include people other than spouses, i.e. it can be a parent, a child, a sibling, this could result in diminution in the NFP, excuse me. So this is a potentially risky proposition for an estate trustee. On the one hand, the FLA is expressly allowing them to make a dependent support payments without seeking any approval from the court, even when they've been put on notice that the surviving spouse is bringing an application concerning their entitlements under Section 6 of the FLA. But on the other hand, acting without court guidance to determine, for example, how much is reasonable for the quantum of support being given to these other dependents could expose the estate trustee to a significant liability to the surviving spouse for improvident actions, particularly given the fact that the FLA, as I said earlier, states that the election has priority over Part 5 claims of adults. So it may therefore be advisable, even in these circumstances, and notwithstanding the statutory authority to do so, for the estate trustee to still seek direction from the court out of an abundance of caution. So that, at this point, is the end of our discussion about FLA, other than to say, obviously, given these complexities of these types of cases, it's certainly important that an estate trustee and a surviving spouse consult with legal counsel. But I'd be happy to open up the floor to any questions anybody might have.
Thanks very much, Brad and Aaron and Alyssa. If you don't mind, I'd like to start and direct a question to Aaron and Alyssa. And this, Alyssa spoke very briefly about excluded property and made the point that property that was received that was subject to an exclusion that no longer exists is not going to be treated differently in the FLA calculation. I just wanted to ask a question about excluded property generally. We often get questions from beneficiaries that are receiving an inheritance with respect to maintaining that exclusion. And I've always taken perhaps maybe a strict approach and recommended that they segregate those funds from the funds that are held by the family generally. And I guess my question is not, I don't want to put you on the spot and ask you, a question that involves technical law, but really as a matter of convention and practice. When it comes to tracing those kinds of exclusions, how technical is that dealt with by family law lawyers in calculating net family property? Because in trust law, whenever the word tracing is used, I mean, everybody instantly gets a migraine because it gives rise to a whole host of technical doctrine. And I get the feeling that in family law, it may be dealt with a little bit more pragmatically. And I wonder if either Aaron or Alyssa, you have any thoughts on that point?
Yeah, so it can be a bit of a minefield in terms of when there is a tracing exercise that is required. So yes, as a matter of course, we would always advise our clients that if they are going to be receiving an inheritance, that they make sure to keep that money separately. And what I mean by separately is it could be in a TFSA just in their own sole name, could be in a savings account. The moment that you put it into a matrimonial home, it loses its character or nature as an exclusion, right? So if you had the inheritance and you put it on into the matrimony, go down on the mortgage or something to pay down joint debts registered against them at home, it loses its character as an exclusion. But where you have an inheritance that, went from a sole savings account and then it went into the joint checking account and then it sat there for a little bit and people's paychecks went in for a period of time and then the family continued to spend and then there was a pot of money that was then moved back to a sole savings account, and the exercise can just get more and more complicated. Actually, my partner, Alana Zilberman Dembo, a number of years ago, co-wrote a great paper on on tracing issues that can arise, and it can become very complicated, and of course, requires a lot of proof, right? So you'd have to actually then show all of the bank statements, show the funds that went in. And then of course, there's also different schools of thought, and you can correct me if I'm wrong, Alyssa, just in terms of how courts consider this. Is it sort of like, first in, last out, or is it first in, first out? And so there's this different approaches that different courts can take in terms of how they will determine whether something has lost its character or nature as being an excluded asset. I'm not sure if you have something more to add than that, but.
Yeah, I mean, I think exactly what Aaron said. To answer your question squarely, David, it is technical if you're going down that path. So the best practice advice is to tell people to keep it separated, and ideally not commingle it with other assets. You can still trace it in that case sometimes, but it gets more complicated. So you might lose some or all of the exclusion depending on what's happened. So definitely the best practice is to keep it separate. And then if you've kept it separate and it's less than what it was originally. So in my example originally was you inherited $100,000, you put it into a separate account and then maybe you moved it into another separate account, but that's easy to trace. Then you spent $20,000 to pay down your mortgage. At the end of the day, it's still very clear and traceable that the $80,000 that's left is the inheritance. So that's what would be in the calculation of your net family property and then excluded. But once you put it into other monies are getting mixed in, that's when it gets complicated, and it gets even more complicated if you're putting it into an account that is joint with the other person, because then half of it is theirs. So that's
very sorry to hear that you get the same migraines that we do when we talk about tracing.
Exactly.
That's disappointing. I thought that somehow the Family Law Act allowed a little bit of a sleight of hand to get to a pragmatic result, but unfortunately, I guess that's not the case. We have, before I open it up to the floor, there's at least one question in the chat bar that we can address. How's a RIF where the spouse is the beneficiary dealt with? That is the asset value of the RIF for the purposes of calculating the equalization amount, I presume. Oh, do any of the presenters wish to comment on that?
So like I said in my part of the talk is that property is defined very broadly. So a RIF, just like an RSP before it becomes a RIF, is part of your property. So you would put in the value, and then what we would do in the family law context is take off some sort of contingent or notional disposition costs, as Aaron talked about a little bit, that sometimes you'd just estimate it. Sometimes you'd have to get someone to help calculate that, an expert to an actuary to calculate it, but that would come out. So it would be the net amount that's included. And then I guess there are some complications that Aaron also touched on about these types of assets about the day before death. But I think for this, because there would have been, even before the death, that there would have been taxes owing on it. I don't think it really makes a difference in the death context versus the separation context.
Thank you. Let me read another question out from the chat bar, and then we'll open it up to people that want to just unmute themselves and ask a question. So this is the question. In the case where a spouse is a beneficiary of a family trust, would the distribution received by the beneficiary from the trust be excluded from NFP calculations? How is the beneficiary's interest in the trust accounted for in a divorce matter, or in the context of equalization, of an equalization election, and the beneficiary/spouse dies? So this is just distributions from family trusts as a matter of how it's captured by the equalization claim.
Well, that is, it's again, sort of a CLE program, I suppose, onto itself in terms of the value, whether being a discretionary beneficiary of a family trust, property for NFP purposes. And that's a whole sort of separate topic in how you would value that. And I mean, the short answer is that, and I'm not just trying to bunt it, but is that it's very fact specific. Okay, it depends on a lot of things. It depends on, among other considerations, whether the beneficiary is also, a trustee, the element of control, whether there's, what been prior distributions and that kind of thing. So certainly, I think it's safe to say that, it can be, and so then quantifying, what that would be for NFP purposes, is a whole separate issue.
Thank you very much. If anyone has a question that they would like to ask, unfortunately, we could try to use the put up your hand feature, but there's just too many people on different screens. So can you just unmute yourself and perhaps ask your question if you don't mind?
If I may.
Go ahead.
Okay, so my keyboard was not working properly. I put a question in the chat that given that at the time of marriage, the gifts like jewelry is given to both the parties, how that will be equalized as an excluded property or for both NFF?
So at the beginning of the marriage, as I understand it, the gift is given to both spouses. Is it subject to an exclusion in the hands of each spouse, or how is it treated?
Yes.
Well, I guess if there was something that was done in advance of the actual, marriage, then it would be technically a date of marriage deduction, right? As Alyssa had said, if it's something that was given, after the date of marriage, then it, again, it could be, again, assuming that it's been properly done and gifted, it could fall into the category of an exclusion, but just to be clear, it can't be both a date of marriage deduction and an exclusion. It's one or the other.
And I think also if it was given post-marriage and it's a proper gift and it was given to the spouses jointly, another component is whether it still exists on the date of separation. And if it does, and it's still joint, then half of it would fall into each party's net family property, and that same half would be excluded.
Thank you.
I wanted to follow up, if I could, on the RIF question. If the RIF of the testator has the wife as a beneficiary on his death, there would be no tax due because it would just flow over to the wife or spouse. But then the spouse then, if the asset is included then in the testator's assets, it strikes me as not being fair that the spouse who then has that income stream after the date of death gets to value the asset and has the income stream, and that's not calculated as part of her NFP, if I'm reading it strictly. Any comments about that?
It's a good question. Not sure that I have the answer.
All right, no, all right.
I think that's probably part of some of those, the category of issues that specifically arise on death, obviously, and so that's not my area of expertise. So I don't know if, I don't want to put Brad on the spot, but I don't know if Brad has an answer to that.
Could I just ask for a clarification? The question you're asking is, after one spouse dies, leaving the other surviving spouse as a designated beneficiary of a RIF, which would be rolled over to him or her on a tax-free basis.
Correct.
If there's then an equalization election, which would place the proceeds of the RIF back into the estate,
Yes.
it would then be, it would have a tax consequence. Is that is?
No, let's argue the tax consequences in a minute. Let's just argue the fact that the surviving spouse gets the benefit of the income stream, but then that is not calculated in her net family property calculation because that comes along after.
Oh, I see. Okay.
So it's a strange, I mean, there might be an argument about fairness in terms, we'll say that it might deplete or eliminate her argument for spouse support, dependence relief claim. But that's different. This is just assets added up and subtracted. And it's just interesting that if I just followed the direction, that asset stays there and the other party, the other spouse who's challenging, doesn't have to put that current value of that income stream into their calculation of NFP. I just wondered whether that had ever been done because of the intricacies in a fight like this. Gets pretty complicated from my perspective.
Well, it may be simply a matter of like, that's a consideration then for the surviving spouse, to consider whether they do in fact want to make the election for equalization, right? Like if they are the beneficiary of the RIF, for example, and then it rolls over, if they are also if they are on a joint tenant, let's just say, of the matrimonial home, and then the deceased spouse half interest in the home rolls over, right? Pursuant to a joint tenancy as opposed to tenants in common, or it would form that part of that person's estate. If it rolls over, I mean, that's a consideration that might mitigate against them wanting to make the election for equalization. right? I mean, it's just certainly something to consider if they know that they are actually the beneficiary of that RIF, and they know that they are going to get it, then that may be something for them to consider. And again, I think that's part of the analysis for looking at what you may be entitled to then under, you know, the will or an intestacy versus if you were to make the election equalization. Does that help?
Maybe.
I just think I could just, it occurred to me as we spoke in terms of because that's the keynote I make was it's one day before death when you start to roll this out. And when I'm dealing with a number of estates, it's very interesting how that has happened and the impact of that. So it may be an issue that has to be considered, or there may be some other law. I just thought if you knew, I'd like to know, but if we don't, we'll have to find out maybe.
It gets a little bit more complicated yet if you say that the beneficiary designation is actually in the will, and then there's an equalization election not to take under the will. And now the questions are going to become whether the prior designation is effective or not effective. In any case, we've got time for one more question. May I ask whether someone would like to ask a question? Anybody going once? Twice? 2.5? Okay, sold. Let's look into the chat bar. Doesn't look like there's any questions that I can see here. We are at 12:59 according to my clock. And I think that
I have a question, if there's still time.
Okay.
My question is about the election and whether or not it can be revoked after it's been made. And that's basically it. Yeah. Can the election be revoked after it's been made, or is it an irrevocable decision by the surviving spouse?
So the answer to that is that the FLA itself doesn't actually have any express provision allowing for the revocation of an FLA, but the most recent case law suggests that the court retains a residual discretion to revoke an election. And they say it should be exercised in sort of restricted circumstances, basically when the interest of justice requires it. Essentially, it's an equitable assessment where the court thinks it's fair in certain circumstances based on a specific fact. They'll use this residual discretion to permit the revocation, but under the statute itself, there is no express entitlement.
Thank you very much, Brad. That brings our seminar to a conclusion. Thank you all for attending. There is a certificate of attendance in the chat bar, which you can download. We'll look forward to seeing you at our next seminar, which was on update on joint family ventures on October 1st, which will be chaired by Greg Sadlowski of Wagner Sadlowski and Hillary Engel of Epstein Cole. If you haven't registered yet, you can do so through a link that's posted in the chat bar. And as a final reminder, the link to the B'nai B'rith Canada Food Program can also be found in the chat in case you would like to donate to this worthy cause. Once again, thank you very much to our presenters, and thanks to all of you for attending. Have a very nice day. Bye.